Hello and welcome back to the Deep Dive. I want you to picture a scene for a second.
Huh?
You are standing in a courtroom, your palms are sweating, your heart is racing, and you are looking at a judge who, well, does not look happy.
Mm-hmm.
You didn't rob a bank with a mask, you didn't mug anyone in an alley, you didn't even leave your house.
Right.
All you did was upload a PDF to a server, or maybe you just exaggerated a little bit on a form because you thought, hey, insurance companies have plenty of money, they won't miss this.
Sure, a common thought.
And yet, the prosecutor is standing there asking for a sentence that rivals what you might get for manslaughter.
It sounds like a nightmare scenario, doesn't it?
Yeah.
But that is the reality of the statute we are looking at today.
It really is. Today, we are cracking open a document that most people would probably use as a doorstop and never, ever actually read.
Probably.
We are looking at Texas Penal Code, Chapter 35. Specifically, insurance fraud. And I have to admit, when I first saw this on the schedule, I reached for my coffee because I thought, okay, administrative paperwork, great.
Uh-huh, I get that reaction.
But then I started reading the notes you prepared, and I realized this isn't just paperwork. This is, and I'm not exaggerating, a hunting license for the state.
That is a very vivid way of putting it, but you know what? You're not wrong. This chapter is the state's rule book for catching deception. And what people don't realize is how incredibly broad the net is. The law has evolved to catch not just the guy burning down his warehouse, but the person clicking a button on an app.
Exactly. So today we're going to uncover how the law defines a lie, how they use this kind of high-stakes math to decide if you get a ticket or a prison sentence, and the weird hidden traps in the code that can turn a small mistake into a life-ruining felony. But before we dive into this legal minefield, I have a quick favor to ask. We spend a lot of time digging through these statutes so you don't have to, and the best way you can support us is to just hit that subscribe button right now.
It really helps.
It helps the channel grow, it helps us keep the lights on, and it ensures you never miss a deep dive. Also, check out our website for the full breakdown and resources related to what we are talking about today.
Please do. It really does make a huge difference for us.
All right, housekeeping done. Let's get into the weeds. Texas Penal Code, Chapter 35. The first thing that hit me was just the sheer scope of this thing. We have to start where the law starts. Section 35.001, the definitions.
Right, and I know definitions sound boring, but in criminal law, the definition is the battlefield. If you fall inside the definition, you are in the game. If you fall outside, you are free.
So let's look at the playing field. The first definition is insurance policy. Now, if you stop 10 people on the street and ask them what an insurance policy is, they're going to say car insurance, health insurance, maybe life insurance. That's it.
That is the standard view, absolutely. But the Texas Penal Code takes a much, much wider view. Section 35.01 says an insurance policy is, yes, all those standard contracts and binders of coverage, but it also explicitly includes something that might surprise you. Motor club service plans.
Motor club service plans.
Yeah.
Like AAA, or those roadside assistance packages you get when you buy a new car.
Exactly those.
Okay, I have to push back on this immediately. Why? Why is that in a penal code about insurance fraud? That feels like a service contract. I pay a membership fee. If my car breaks down, you send a tow truck. Where's the risk? Why is the state treating that like a high-stakes financial instrument?
Because of the potential for systemic abuse. Think about the ecosystem of roadside assistance. It's not just you and your flat tire. You have a dispatcher, you have a tow truck driver, and you usually have a repair shop involved somewhere down the line.
Okay.
It's a cash-heavy, often chaotic environment.
Okay, I think I see where you're going. It's not about me getting a jump start. It's about the back end.
Precisely. If the law didn't classify that motor club plan as insurance, you could have these massive schemes where, say, tow drivers create ghost tows.
Those tows.
Yeah, they bill the motor club for towing cars that never moved, or they tow a car 5 miles but bill for 50. If that's just a contract dispute, it's a civil matter, it's a lawsuit.
Right, he said, she said.
Exactly. But by putting it in Chapter 35, the state is saying, no, if you lie to the roadside assistance company to get a payout, you are committing a felony. It's not a business dispute anymore.
It criminalizes the breach of contract. That is fascinating. So it effectively closes a loophole for the entire towing and repair industry.
It does, and it goes even further. The definition includes surety bonds and cash bonds, and then just in case they missed anything, it has a catch-all clause. It covers any other alternative to insurance authorized by Chapter 601 Transportation Code or regulated by the Texas Department of Insurance.
So they basically built a fence. They built a fence around every pot of money that exists to cover risk.
They did. If it looks like insurance, acts like insurance, and is regulated like insurance, you can go to prison for lying to it.
Speaking of lying, let's look at the next definition. Statement. This is section 35.01, subsection 5. This is where I feel like the law finally woke up and realized it is the 21st century.
It really did. This definition is absolutely critical in the modern era.
Usually when I think of a statement in a legal context, I'm thinking of an affidavit. I'm sitting across from a cop or an adjuster with a tape recorder saying, I was driving down Main Street and the light was green. That's a statement.
That is definitely a statement. And the law covers that oral or written communication, but then it adds a phrase that changes absolutely everything. The term includes computer-generated information.
Computer-generated information. Unpack that for me. Does that mean a click is a statement?
It means much more than just a click. Think about how modern insurance works. Let's say you have one of those dongles in your car from your insurance company, the ones that track your speed and your braking to give you a discount.
The tattletale devices.
Right, the tattletale. Or let's say you drive a modern car that uploads crash data telemetry directly to the cloud after an accident. If you were to tamper with that device, if you were to hack the data to make it look like you were going 35 miles per hour when you were actually going 90, you haven't spoken a word to an adjuster. You haven't written a letter. You haven't signed a form.
I've just manipulated zeros and ones.
Exactly. But under this statute, that manipulated data is a statement. You have generated false information and presented it to the insurer.
So the data itself is the witness.
Yeah.
And falsifying the data is the perjury.
Yes. And think about medical billing. This is huge there. When a hospital's billing software batches 5,000 claims and sends them to Blue Cross, no human being sits there and signs each one. The computer generates the batch file.
Right.
If the algorithm in that software is rigged to upcode to charge for a more expensive procedure than what was actually done, that computer-generated batch is a fraudulent statement under the law.
That is massive. It completely removes the I didn't say that defense. You can't say, well, I never technically lied to anyone's face. The law says you lied to the server and that counts.
Precisely. It acknowledges that in the modern world, the biggest frauds happen in the code, not in the conversation.
Okay, there's one more definition we need to flag before we move on, and that is value of the claim. We are going to do a massive deep dive on the math of this later because it's complicated, but give us the headline for now.
The headline is that in theft and fraud, money equals time. The value of the claim is the metric that determines if you get a slap on the wrist or go to prison for decades. Generally, it means the total dollar amount of the claim for payment. But as we will see, figuring out what that total amount really is can be a legal nightmare.
Okay, so we know the playing field. We know what a policy is. We know what a statement is. Now, I want to play devil's advocate for a minute.
Go for it.
Because the definitions are so broad, I feel like I could accidentally commit a crime. What if I fill out an application for life insurance and I say I weigh 175 pounds, but I actually weigh 180? I lied. I made a false statement to an insurer. Am I going to jail?
That is the fear, right? Over-criminalization, the idea of I checked the wrong box, now I'm a felon.
Exactly.
That brings us to section 35.015, materiality. This is the safety valve of the statute, but it is also the litmus test. The law doesn't care about every lie. It only cares about the lies that matter.
The so what test.
Right. The official so what test of the Texas Penal Code. The statute says a statement is material only if it affects one of two things. First, the eligibility for coverage or amount of the payment on a claim.
Okay, so back to my weight example. If I shave off 5 pounds on the form, does that change my premium?
Probably not. The actuarial tables aren't that sensitive, so if the lie doesn't change the amount of money you pay or of the money they pay you, it's likely not material. But let's change the facts. Let's say you lie and say you are a non-smoker when you smoke 2 packs a day.
That definitely changes the premium.
It changes the premium drastically. Or they might not insure you at all. Which brings us to the second criteria. Did the statement affect the decision of an insurer whether to issue an insurance policy?
So getting in the door.
Exactly. If the lie is the key that unlocks the door to coverage in the first place, it is material. But there is a really fascinating, somewhat mind-bending nuance in this section that I want you to look at.
I'm looking at the text here. It says a statement is material regardless of the admissibility of the statement at trial.
Regardless of the admissibility.
Translate that for me. Because that sounds like a paradox. How can something matter for the crime if it's not even allowed in court?
It is a legal paradox. In a criminal trial, we have the rules of evidence. They're incredibly strict. Hearsay is banned. Illegally obtained evidence is thrown out. Unauthenticated documents are inadmissible. The court is very, very picky about what a jury is allowed to see.
Right. You have to play by the rules to convict someone.
Usually, yes, but this definition is saying something different. To determine if the crime of fraud occurred, we don't care if a judge would later let that piece of paper into a courtroom. We only care about the impact the statement had on the insurance company at the time it was received.
Wait. So theoretically, I could be in court and my defense lawyer could argue, Your Honor, you can't show the jury that email I sent because it's hearsay. And the judge says, you're right, the email is inadmissible, but I can still be guilty of the fraud.
Yes, because the element of the crime materiality is satisfied by the effect of the lie, not the procedure of the trial. The law is focused on the mechanics of the deception itself. Did the lie fool the insurer? Did it affect their decision? If yes, it's material. The statute prevents a fraudster from saying, well, sure, I lied and sure they paid me, but you can't prove the lie in court because of a technicality.
Wow.
The statute cuts right through that and says, the lie did its work. You are guilty.
That is incredibly aggressive. It's like saying the bullet hole proves the shooting, even if we can't find the gun.
That is a great analogy. The damage was done at the moment of deception.
Okay, let's move to the main event. Section 35.02, the offenses. This describes the actual crimes. And before we get to the specific types, we need to talk about the golden rule of this entire chapter.
Intent.
The text says, a person commits an offense if, with intent to defraud or deceive an insurer.
This is the most important protection you have as a citizen. You cannot accidentally commit insurance fraud under Chapter 35. You have to mean it.
So if I genuinely get the date of my accident wrong on a form, or I accidentally type an extra zero on a spreadsheet but I didn't guess it?
That is negligence. That is a clerical error. It is not a crime. To be a crime, the prosecutor has to prove you had the mens rea, the guilty mind, the intent to deceive. They have to get inside your head and prove you knew it was false.
That is comforting. So, assuming I do have the intent, I am trying to pull a fast one. The law breaks this down into two main flavors. Let's call them Scenario A and Scenario B.
Scenario A is in subsection A. This is fraud in support of a claim.
This is the classic stuff. I crashed my car, give me money.
Right. The elements are very straightforward. You prepare a statement or you cause one to be prepared knowing it contains false or misleading material information, and you present it to an insurer. And crucially, this must be in support of a claim for payment.
So the goal is extraction. I want cash out of the company.
Yes. You are trying to extract a benefit based on a policy that already exists.
Now let's look at Scenario B in subsection A1. This is fraud in application.
This is different. This isn't about getting a check today. This is about getting the safety net itself. The elements are the same, lying with intent, but it is in support of an application for an insurance policy.
Why does the law separate them? Is it just semantics? They're both lying to an insurance company.
No, it's a fundamental difference in the harm done, and as we will see when we get to the punishment ladder, they are treated very, very differently. Claim fraud is punished based on how much money you try to steal. Application fraud is a flat felony.
A flat felony, no matter what.
No matter what. We will unpack that in a minute. But it shows that the legislature views the act of corrupting the insurance pool from the very beginning as a specific, dangerous type of crime.
Okay, before we get to the punishments, there's a third type of offense in Section 35.02b that we need to discuss. And honestly, this is the one that feels the most like an episode of The Sopranos.
The kickback statute, or as it's often called in the industry, the runner statute.
The runner statute. Explain the ecosystem here, because so far we have been talking about the lone wolf, the guy who lies about his car. But this section seems to go after something organized.
It does. You have to understand, the biggest insurance fraud costs don't come from individuals exaggerating a dent. They come from organized rings. You have a personal injury lawyer, a chiropractor, a body shop, and a tow truck driver. And they are all feeding each other.
The circle of life, but for crime.
The circle of fraud. Think about how it works. You crash your car, a tow truck shows up, the driver says, hey, I know a great body shop that can waive your deductible.
Sounds like a nice guy.
He's not being nice. He's getting paid $200 cash by the body shop for bringing that car in. He's a runner. Then the body shop guy says, hey, your neck looks a little stiff. You should go see Dr. Smith.
And Dr. Smith pays the body shop a referral fee.
Exactly. And then Dr. Smith treats you 3 times a week for 6 months for a non-existent injury and sends the inflated bills to the lawyer, who then sues the insurance company. Everyone in the chain gets a cut.
And who pays for it in the end?
We do. Every single legitimate policyholder pays higher premiums to subsidize this corruption.
So subsection B is the weapon designed to blow that entire network apart.
Yes. It says it is an offense to solicit, offer, pay, or receive a benefit in connection with furnishing goods or services for a claim.
Any benefit, that is broad.
It is incredibly broad. If the body shop guy buys the tow truck driver a steak dinner in exchange for the car, that's a benefit.
Yeah.
If he gives him courtside tickets to the Mavericks game,
That's a benefit.
if he hands him an envelope of cash behind the dumpster, definitely a benefit.
And notice the verbs here. Solicit, offer, pay, receive. It catches everyone. The guy handing the envelope, the guy taking the envelope, and even the guy who asks for the envelope but doesn't get it.
It is a total prohibition on the marketplace of referrals in insurance. You cannot pay for the privilege of treating a patient or fixing a car if it involves an insurance claim. Period.
That makes it so much easier for prosecutors. They don't have to prove the car wasn't damaged. They don't have to prove the neck wasn't sore. They just have to prove money changed hands for the referral.
Exactly. If they find that check or that Venmo transaction, the crime is complete. It's a much cleaner case to prove.
Okay, so we have established the crux: claim fraud, application fraud, and kickbacks. Now, let's talk consequences. This is section 4 of our outline, the ladder of punishment. And I want to skip the small stuff for a second. We know if you steal $50, it's a misdemeanor. Fine. I want to talk about the moment this gets real, the moment you become a felon.
That happens at $2,500.
That number is shockingly low to me.
Hmm.
$2,500? I mean, if I sideswipe a luxury car, the paint job alone is probably more than that.
Yeah.
If I lie about that, I'm a felon.
You are specifically a state jail felon. And let's be clear about what that means in Texas. A state jail felony isn't county jail where you do a few weekends and go home. It is a specific prison system. It carries a sentence of 180 days to 2 years, day for day.
And the collateral consequences.
Massive. You lose your right to vote. You lose your right to own a firearm. If you have a professional license, if you are a nurse, an accountant, a realtor, a teacher, that license is likely gone. Your career is over.
For a $2,500 lie.
For a $2,500 lie.
That is terrifying. But then we climb the ladder. The punishment scales with the value of the claim. $30,000 gets you a third-degree felony, that's 2 to 10 years. $150,000 gets you a second-degree felony, 2 to 20 years. And $300,000 gets you a first-degree felony, 5 to 99 years or life.
Right. Those correspond to the standard theft ladder that most states have. But there is a trapdoor in this statute, a way to hit that absolute ceiling of punishment, first-degree felony, without stealing a single dime.
This is the life and limb clause, subsection C7B. This gave me chills when I read it.
It should. It says the offense is a first-degree felony if an act committed in connection with the commission of the offense places a person at risk of death or serious bodily injury.
Places a person at risk. It doesn't say hurts a person. It doesn't say kills a person. Just risks it.
Correct. So let's play out a scenario. The swoop and squat.
The swoop and squat sounds like an exercise move.
I wish. It is a staged accident technique. You have 2 cars working together. They box in a victim on the highway. The lead car, the swoop car, swerves in front of the victim and slams on the brakes. The victim has no choice but to rear-end them.
Creating a fault accident so they can claim whiplash and other injuries.
Exactly. Now, usually they try to do this at lower speeds, but let's say you do this on I-35 outside of Austin. Traffic is moving at 70 miles per hour. You slam on your brakes, the victim behind you screeches, swerves, maybe spins out. Nobody actually gets hurt. They just bump bumpers. The damage is only $1,500.
So based on value, that should be a Class A misdemeanor, a slap on the wrist.
Normally, yes. But because you staged that accident on a highway at 70 miles per hour, you place the other driver and everyone around them at risk of death or serious bodily injury.
So the prosecutor looks at that $1,500 bumper and says, nope, you rolled the dice with human lives, first-degree felony.
Exactly. You are now in the same sentencing bracket as a murderer. You are looking at 5 to 99 years.
That is moral clarity from the law. The law is saying money is money, we can count money. But if you turn the public roads into a weapon just to get a payout, we're going to bury you.
It is the ultimate deterrent against the arsonist mentality. People who burn down occupied buildings or crash cars without caring who gets hurt in the process.
Now, we mentioned earlier that application fraud lying just to get the policy in the first place is treated differently. Where does that fit on this ladder?
It doesn't fit on the ladder at all. It has its own designated spot. Subsection D simply says, an offense under subsection A1 is a state jail felony, period.
No dollar amounts. No sliding scale.
No dollar amounts. It doesn't matter if the policy was for $10,000 or $10 million. The act of lying on the application is automatically a state jail felony.
Why? Why not scale it like the claims? What's the logic there?
Because with an application, you haven't stolen a specific amount of money yet. You've stolen coverage. You've corrupted the risk pool from the very beginning. The legislature decided that the act itself is serious enough to warrant a baseline felony, regardless of the potential payout down the road. It's about protecting the integrity of the system's entry point.
That is simpler, but also much harsher. There is no misdemeanor buffer. If you lie on the app, you are a felon.
Correct. And we should mention, prison isn't the only punishment. Subsection E adds financial insult to injury.
Restitution.
And not just regular restitution. The court shall order the defendant to pay it. And that implies paying back the claim money, obviously. But the statute explicitly says it includes court costs and the insurer's attorney's fees.
Oh, wow. So if the insurance company spends $50,000 hiring investigators and lawyers to prove you lied,
you are footing that bill. So you go to prison, you lose your rights, and when you get out, you have a massive non-dischargeable debt hanging over your head.
the system is designed to crush you, financially and legally.
It is. It's designed to make fraud a very, very bad bet.
Okay, we have talked about the latter based on value. But earlier you said calculating value can be tricky. This brings us to Section 5 of our outline, the math of fraud. And I have to be honest, this next part feels generous, which is weird for a penal code.
You are talking about the valid loss defense in Section 35.02G.
Yes, it basically says, if you try to steal $10,000, but only $2,000 of it was a lie, we only charge you for the $2,000.
Why?
If I rob a bank and I drop half the money on the way out, I'm still charged with robbing the bank. I don't get a discount for the money I didn't successfully keep.
That is a fair critique. But think about the nature of insurance. Unlike a bank robbery, where the entire interaction is a crime from start to finish, an insurance claim often starts with the truth.
Okay, I really did hit a deer.
You really hit a deer. Your hood is smashed. That is a valid contract claim. The insurance company owes you that money. That debt is real.
Right.
But then you decide to get greedy. You take a hammer to your headlight to make sure they replace the whole assembly. Or you claim your expensive golf clubs were in the trunk and got broken too when they were actually at home.
The padding.
The padding. If the state charged you with the full value of the claim, the hood, plus the golf clubs, they would be punishing you for asking for money you were actually owed. The hood damage isn't fraud, it's a debt the company owes you. And the state cannot criminalize the collection of a valid debt.
I see. So legally, they have to surgically remove the truth to isolate the lie.
Exactly. They have to carve out the cancer. So the math is total claim minus valid amount equals the value of the claim for punishment purposes.
So if I claim $10,000 and $8,000 of that was real damage from the deer, I'm only charged for the $2,000 lie about the golf clubs.
Correct.
That drops me from a state jail felony, which is what $10,000 would be, down to a Class A misdemeanor for the $2,000.
It does, but, and this is a massive, massive but, do not think this is a get-out-of-jail-free card. The burden of proof flips completely.
What do you mean? In criminal law, isn't the burden always on the state? Beyond a reasonable doubt?
For guilt, yes. The state must prove you lied. But for this specific deduction, the statute explicitly says, if the actor proves by a preponderance of the evidence.
If the actor proves. So I have to prove the truth.
Yes. You, the defendant, standing there at the defense table, you have to bring the receipts. You have to convince the jury by a preponderance of the evidence, more likely than not, no, the hood really was smashed by a deer. The state doesn't have to prove the hood wasn't smashed. You have to prove it was.
That is a huge risk. So if I pad a claim, I am risking the legitimate money I was owed. I'm gambling that I can prove the valid part while I'm on trial for the fake part.
Exactly. And if you can't prove it, if the jury doesn't believe your story about the deer, the law allows them to count the whole $10,000 as fraud, and you get the felony.
That turns padding into an incredibly high-stakes gamble.
That is the entire point.
Now, what if the value isn't obvious? Let's say I claim I lost a rare painting in a fire. Or I claim I lost a magic rock that I say is worth $1 million, but obviously it's just a rock. Who decides what it's worth?
That takes us to Section 35.025. This deals with situations when the value is not readily ascertainable.
How do they figure it out? What's the process?
Well, first they try to find the fair market value at the time and place of the offense. What would a willing buyer pay for this item? If that doesn't work, say for a unique item, they look at replacement cost. What would it cost to replace it within a reasonable time?
Okay, but what if we still can't figure it out? What if it really is a unique, weird item and there's no market for it?
The law has a default setting for that exact problem. It's in Section 35.025b. If the value cannot be reasonably ascertained by any of those methods, the goods or services are considered to have a value of $750 or more, but less than $2,500.
Yeah, the Class A misdemeanor range again.
Yes, it's a safety net for the prosecution. It ensures that just because the value is murky, the criminal doesn't walk away scot-free. It locks them into a significant misdemeanor by default.
That feels like a trap for the defense. It prevents the "you can't prove what it was worth, so you can't charge me" argument.
Precisely. The law says if we can't prove its value, we'll assign one and it won't be a slap on the wrist.
All right, let's talk about supersizing the charges. This is Section 35.03, aggregation. Because criminals are smart. They know about the felony thresholds. So what if I decide, okay, I won't submit one big fake bill for $30,000. That's a felony. Instead, I'll submit 50 small fake bills for $600 each. Those are just misdemeanors.
That is the death by a thousand cuts strategy. And Section 35.03a is designed specifically to stop it.
How? How does it work?
It says when separate claims are communicated pursuant to one scheme or continuing course of conduct, the conduct may be considered as one offense.
And they add money up.
They aggregate the values. So those 50 separate claims of $600, the law sees that as one aggregate claim of $30,000.
And $30,000 is a third-degree felony.
Correct. You tried to be clever and stay in misdemeanor land, but the law grouped your actions together and dragged you into felony court.
Now, there is another aggregation rule in subsection B that doesn't involve adding the money. This is what you call the three strikes escalation.
This is an alternative tool for prosecutors. If you have 3 or more separate claims in one scheme, and for some reason the state isn't aggregating the dollar values, maybe the values are tiny or hard to prove, they can use this rule instead.
What does it do?
It bumps the classification of the offense one category higher than the most serious single offense.
Okay, give me an example of that.
Let's say you have 3 separate fraudulent claims. The biggest one is a Class A misdemeanor. Under this rule, because there are 3 or more instances, the offense level jumps up one step. So instead of being charged with a Class A misdemeanor, you are charged with a state jail felony.
So even if the money is small, the sheer volume of the fraud, the pattern, turns you into a felon.
Exactly. It punishes the pattern of behavior. It says you are a habitual liar and we are now treating you like a felon.
Is there a limit? Can I go from a first-degree felony to a super first-degree felony?
Laughs. No. The statute caps it. If the most serious offense is already a first-degree felony, it stays there. You can't go higher than first degree.
Makes sense. I guess once you are facing 99 years, you don't really need to go much higher.
Exactly. The point has been made.
We are coming into the home stretch here with Section 7 of our outline. Legal mechanics and procedures. This is the how the sausage is made part of the prosecution.
Yeah.
And there's some really interesting procedural levers the state can pull.
There are. These are the tools that make the prosecutor's job easier.
First up, Section 35.02, double trouble.
That's a good name for it. The statute says if your conduct constitutes an offense under this chapter and another law, you can be prosecuted under this section, the other law, or both.
So let's go back to the guy who burns down his warehouse to collect the insurance money.
That is arson, a very serious felony. And it is insurance fraud, also a serious felony.
And the state doesn't have to choose. They don't have to pick one lane.
Nope. They can charge you with arson and insurance fraud. You can face penalties for both. You can even have the sentences run consecutively, one after the other. It allows the state to pile on the pressure and reflect the full criminality of the act.
That is a very, very bad day in court for that defendant.
A very bad day.
Next, let's talk about the bill submission presumption in Section 35.028. This seems like a tool specifically for catching those crooked doctors or mechanics we talked about earlier.
It is. Often in these fraud cases, the defendant says something like, look, I didn't mean to submit that as a formal claim. I was just sending a bill for my records. I was just brainstorming.
I was just testing the system.
Right. Subsection H shuts that whole line of defense down. It says if you submitted a bill for goods or services to an insurer, A rebuttable presumption exists that you caused the claim to be prepared or presented.
So the default assumption of the court is, if you sent the bill, you meant for it to be paid.
Yes, it shifts the burden. You, the defendant, have to prove you didn't mean for it to be a claim. The state doesn't have to prove you did. The act of sending the bill creates the presumption of intent.
That makes it much, much harder to play dumb.
Exactly. It forces you to have a very good reason for sending a bill to an insurance company if you didn't want them to pay it.
Finally, Section 35.04, the Attorney General.
Usually, crimes are prosecuted by the local district attorney. But insurance fraud is often incredibly complex. It can involve forensic accounting, digital data analysis, and schemes that cross multiple county lines. A local DA in a small rural county might not have the budget or the specific expertise to chase a multi-million-dollar telemedicine fraud ring.
So the cavalry comes in.
The cavalry comes in. Section 35.04 gives the Texas Attorney General jurisdiction to help. They can offer investigative, technical, and litigation assistance. Or, if requested by the local DA, the AG's office can prosecute the case directly.
This tells me the state puts serious resources behind this. They aren't leaving it up to chance or a small county's budget.
No. They bring in the big guns. It signals that protecting the integrity of the insurance system is a state-level priority.
So we have covered a lot of ground today. Let's zoom out and just look at the big picture for a second. We started with definitions, learning that insurance covers everything from roadside assistance to surety bonds, and that statements include your digital clicks and data uploads.
We learned about materiality, that the lie has to matter. It has to affect the money or the risk, and it doesn't matter if a judge would later allow the evidence in court.
We broke down the offenses: claim fraud, which is getting money out, application fraud, getting coverage in, and the kickback statute, which targets the dirty ecosystem of referrals.
We climbed that scary ladder of punishment from the petty misdemeanor all the way up to a $300,000 first-degree felony.
And we saw that crucial life and limb clause, that putting someone at risk of death on the highway makes it a first-degree felony immediately, regardless of the money.
We did the math on valid loss, the high-stakes gamble of padding a legitimate claim.
And we looked at aggregation, how the state adds up multiple small claims to hit you with one big felony charge.
It is a comprehensive and I would say a very aggressive system. The goal of Chapter 35 is to make the cost of fraud far higher than any potential benefit. It attacks the intent, the mechanism, and the financial gain from every possible angle.
Before we wrap up, I want to leave our listeners with one final thought, something we touched on briefly but I think deserves a moment of reflection.
The moral equivalence.
Yes, the risk of death clause. The law equates a financial crime of $300,000 with an act that physically endangers someone. Both are first-degree felonies. Both carry the same potential life sentence.
It is a profound statement by the legislature, isn't it?
It suggests that at a certain point, society views financial fraud, stealing from the collective pool of insurance, as being just as destructive as physical violence. Why do you think that is? Why draw that parallel?
I think it's because insurance, at its core, is based on trust. It is a community safety net. We all put money into a pot so that when one of us falls, we get caught. When you drain that pool through massive fraud, or when you endanger lives to access that pool, you aren't just hurting a nameless corporation on a skyscraper. You are destabilizing the safety net for everyone. You're making it more expensive, less reliable, and I think the law has no patience for people who break that social contract that violently.
That is something to think about. The law isn't just math. It's a reflection of what we value as a society. Thank you so much for walking us through this. I feel like I could pass the bar exam. Well, at least the insurance fraud section of it.
One chapter down, only a few hundred more to go.
Baby steps. To our listeners, thank you for learning with us today. If you found this useful, please remember to subscribe to the channel. It really does help us out. And check the website for more info.
Stay curious and stay legal.
We'll catch you on the next deep dive. Bye, everyone.